Welcome back to Organized, the business law breakdown. I'm your host, Seth C. Orenberg, and today we're talking about a very important issue in contract law. What happens to an offer when it dies? That's right, not all offers stick around forever. And today we're going to find out what can kill an offer and why they expire. Imagine this. You are on the verge of sealing a great deal, but you hesitate for just a minute. When you turn back to accept the offer, your counterparty says, "Too bad, so sad, it's expired." What happened? Are you out of luck? Today, we're breaking down the ways an offer can become unacceptable, sometimes when you least expect it. In our previous episodes, we've explored how offers are created and the conditions needed to make an offer binding. But an offer doesn't live forever. Like many things in contract law and in life, offers are fragile, and several factors can cause them to be terminated before they mature into a contract. Today, we'll look at the ways an offer can be terminated before it's accepted, through rejection, counteroffer, lapse of time, or even the death of one of the parties. Today, we'll look at the ways an offer can be terminated before it's accepted, through rejection, counteroffer, lapse of time, revocation, and death or incapacity of the parties. We'll dive into real-world cases to see how these rules play out, and as always, we'll explore how they can impact everyday transactions. So, if you've ever wondered whether that limited time offer really expires at midnight, or if your hesitation could cost you more than you think, stick around. We're going to break down exactly when and how an offer becomes unacceptable. Now that we've set the stage, let's dive in to how and when an offer can be terminated. Once we've established there's an offer, it's not going to last forever, but the offer does do something incredible while it exists. It creates in the person who receives the offer the power of acceptance. The power of acceptance is the ability to say yes and make a legally binding contract, but that power can be extinguished in several ways before the contract is formed. According to the Restatement Second of Contracts, Section 36, there are four main ways an offer can be terminated. 1, rejection or counteroffer. 2, lapse of time. 3, revocation by the offeror. And 4, death or incapacity by either party. The first method is simple. If the offeree, the person receiving the offer, rejects it, the offer is dead. A clear rejection, like saying, "No, I'm not interested," terminates the offer immediately. But here's where it gets more nuanced. Making a counteroffer usually also terminates the original offer. A counteroffer functions as a rejection. Let's say you are offered a job with a salary of $100,000, and you request by saying, "I would work for no less than $110,000. In doing that, you've killed that original $100,000 offer, and you've replaced it with a new one. The ball is now in the original offeror's court. You can't go back and accept the $100,000 offer anymore. Next, let's talk about time. Offers don't last forever. If the offeror sets a specific deadline, like this offer is good for 24 hours, then after that time passes, the offer is gone. It's dead. If you try to accept an offer after the time has lapsed, you are actually making a new offer that the original offeror can either accept or reject or counteroffer. If no time limit is given, the offer stays open for what's a reasonable time, and what's reasonable depends on the circumstances. For example, an offer to buy perishable goods might last only a few hours, while an offer to buy a house might last a couple days or weeks. Now, here's where it gets a little trickier. Revocation. The offeror generally has the power to revoke or withdraw an offer at any time before it's accepted. The person who makes the offer is called the master of the offer and can change or destroy it. But, and this is key, the offeree has to receive notice of the revocation to make it effective. And there are situations where offers are irrevocable, such as when there is an option contract, or when a merchant makes a firm offer, or when some of the reliance doctrines come into play. So if you're about to accept an offer, but get a call saying, "I'm withdrawing my offer," your power to accept is probably terminated, even though you were just moments away from saying yes. And this can happen even indirectly. Let's say that someone offered to sell their house to you. And before you accept the offer, you drive by and see that what was once a for sale sign now says sold. You have now received notification that that offer can no longer be accepted. So there are multiple ways in which you can lose your power to acceptance through a revocation. And there are doctrines that make revocation impossible through irrevocability. Finally, there's the issue of death or incapacity. If either the offeree or offeror dies before the offer is accepted, then the offer automatically terminates. The rule feels a little outdated since contract law focuses on intent, and somehow, magically, through the ether, this quasi-notification of death or incapacity happens immediately. Again, you don't actually need to get notification of the other party's death or incapacity. When it happens, it automatically cancels the offer. It's a holdover from when contracts were seen as a meeting of the minds, and if one of those minds is gone, the offer can't survive without it. These rules might seem strict, but they exist to keep offers from lingering indefinitely, because offers mean liability for the offeror. The important takeaway is that once an offer is terminated, it's dead. It can't be revived by trying to accept it later. All you can do is make a new offer, and now the ball's in the other party's court. But understanding exactly when and how an offer dies can help you navigate the world of contracts without losing out on opportunities. Now that we know the main ways offers can be terminated, let's take a look at how these principles play out in real cases. Two of these cases give us a great opportunity to see the offers in action. Let's break them down. Let's break it down with a key case showing how offers can be terminated, sometimes in ways that aren't immediately obvious. And we're going to talk about Smaligo versus Fireman's Fund Insurance Company. In this case, the Smaligo family filed a claim under their uninsured motorist insurance policy. The insurance company offered to settle the case for $7,500, but the Smaligos, who are not happy with that number, went ahead and filed for an arbitration again, seeking more money. Later, they came back to the insurance company and asked for the $7,500. Are they entitled to it? No. Why? When the Smaligos proceeded to arbitration, the court found this was an indirect rejection of the offer to settle the case. Even though the Smaligos didn't exactly say no to the $7,500 offer, by moving forward with arbitration, that showed they weren't interested in the settlement that the insurance company provided. It functioned as a rejection. In this way, an offeree's action, which involved taking steps inconsistent with accepting the offer, can terminate the power of acceptance just as much as a verbal rejection. The key takeaway here is that rejection can be indirect. You don't always have to say no to kill an offer. Sometimes actions speak louder than words. If you engage in conduct that the offeror reasonably interprets as a rejection, the offer is terminated. Let's consider a what-if scenario. What if you're negotiating the sale of a vintage car and you've offered to sell it for $10,000? The buyer says, I'll give it to you for $8,000. What just happened here? This is a classic counteroffer. The buyer's offer to pay $8,000 automatically terminates your original offer of $10,000. The buyer can no longer accept the $10,000 offer that you gave, at least not unilaterally. If you don't want to take $8,000, you can say, no, I'll do it for 10 and resume the offer process. But once the buyer says, I'll give you 8,000 for it, the $10,000 offer is dead unless you bring it back into play. Now, what if you've made the same offer to sell the car for $10,000 and the buyer says, let me think about it? 2 days later, they come back and say they'll take the offer. Is the offer still valid now? Now it depends. If you didn't specify a time limit for the offer, it's probably still open for acceptance within a reasonable time. What's reasonable depends on the context. If you're selling a car, a couple days delay might be fine. But if we're talking about a stock that could move hundreds of dollars in a few hours, that offer could lapse in mere minutes. Finally, let's say you offer to sell your car, but before the buyer can respond, you call and say, "I've changed my mind. I don't want to sell the car." The buyer then says, "No, I want the car anyway. Is there a deal?" Nope. Once you've revoked the offer and the buyer knows about it, their power to accept is gone. Even if they were just about to say yes, your notice of revocation terminates the offer immediately. There's other cases that we can analyze the situation, so let's continue to break it down. Next, let's look at the Yarrows case, Yarrows versus Trustees of the University of Pennsylvania, which deals with the lapse of time in offers. In this case, the university offered to settle a negligence lawsuit for $750,000 right before closing arguments for the case occurred. The plaintiff's attorney asked for time to consult with their client, but then returned to court participating in the closing arguments without accepting the offer. After closing arguments, the plaintiff's attorney attempted to accept it. And the question is whether the offer had been terminated by lapse of time because of the delay in this acceptance. Was the offer only available until closing arguments? The university argued that the offer expired when closing arguments began, but the court disagreed. The university did not clearly specify a deadline for the offer. Instead, the court ruled that it remained open for a reasonable time. In this case, a reasonable time included after closing arguments and before the judge made a ruling, in part because the parties had only a short break to use the restroom facilities before they all resumed trial. There wasn't time for the attorney to speak to his client, which is required under ethical rules before accepting a settlement offer. So the parties should have understood that the offer was still available for acceptance in that case. This case shows that unless there's a clear deadline, offers don't always die at the end of a conversation. There is a concept called the conversation rule, and many offers do die at the end of a conversation. But in this case, where an attorney had a legal obligation to go back and talk to a client around an offer, there was a reason to believe it should continue for longer. Let's talk about how an offer terminates in the world of pop culture. If you've ever shopped online on sites like eBay, you've probably seen that offers are time limited. You'll get a notification saying offer expires in 24 hours, or there is some countdown tied to the end of an auction. What happens if you miss that deadline? Once that timer runs out, the offer is probably dead. Just like in contract law, you can't go back and accept an offer after it's expired. That's what expired means. eBay and similar platforms make it very clear that time is of the essence, and if you don't act within a specified window, the deal is off the table. Another great example comes from the world of film. In the movie The Social Network, there's a moment where Mark Zuckerberg gives an offer to settle with the Winklevoss twins. They make a counteroffer, asking for more money than Zuckerberg initially proposed. But in doing so, they terminated the original settlement offer. This is a perfect demonstration of how a counteroffer kills the original offer. It functions as a rejection, and this is critical in high-stakes legal battles. Sometimes by asking for more, you end up with nothing. Whether it's online shopping or legal negotiation in movies, pop culture shows us that timing and action matters. Just like in contract law, once the timer runs out, the offer is no longer available. As a reminder, in the real world and in fiction, offers don't last forever. With all that in mind, let's quickly recap today's key takeaways. We started by looking at the different ways an offer can be terminated before it turns into a contract, through rejection, counteroffer, lapse of time, revocation, or even death of one of the parties. These methods all lead to one conclusion. Once an offer is terminated, it's dead. There's no reviving it unilaterally. All you can do is make a new offer with the same terms. In the Break It Down segment, we saw how actions like moving forward with arbitration in the Smoligo case can imply rejection even without a direct no. And in the Yarrows case, we learned that unless a specific deadline is set, offers can remain open for a reasonable time, and that amount of time depends on context. The key takeaway: offers are fragile and time sensitive. Whether you're negotiating a deal or shopping online, knowing when an offer can expire or be terminated is critical. timing is everything, and hesitation or counteroffers can quickly change the game. As always, I love to hear your thoughts. Have you ever lost out on an offer because of bad timing or a misunderstanding? Or maybe you've made a counteroffer only to find that the original deal went off the table and you didn't intend that? Share your experiences and questions with me. I might even discuss them in a future episode. Make sure to subscribe, leave a review if you're enjoying the show, and share this with anyone who might find it useful. In our next episode, we'll dive into the mirror image rule and the battle of the forms. And we'll talk about how an acceptance must exactly match the offer to form a valid contract, except for when it doesn't. That's all for today's episode of Organized, the Business Law Breakdown. I'm Seth C. Orenberg, and I want to thank you for tuning in and exploring the death of the offer with me today. I hope you found today's podcast informative and helpful. Remember, until next time, keep your agreements strong and your arguments stronger.